Good evening, everyone. Welcome to this 39 Essex Chambers webinar looking at social care related issues in lockdown 3, as we can call it. And with depressing inevitability, Sian and I are back to cover the thorny questions that arise from the application of the Tier 4 regulations, the toughened Tier 4 regulations to the whole of England with effect from yesterday, I believe it was. So thank you very much for joining. We've had an incredible degree of interest in this session, and there's over 600 people online already. We had 1,000 people booked on, I think, within a day of us announcing that we were doing this session again, and it is a second time round for us because we covered these issues in relation to lockdown 2. And much of what we're going to say today will repeat the discussion from that time, but there have been some important changes in both the law and the guidance. And just to pick up one key theme in today's talk, there is a distinction between the law, which of course we all have to follow, and the guidance, which is what the government would like us to do, but which doesn't have the force of law behind it. So in essence, I'm going to spend the first 20 minutes or so looking at the law, taking you through as best I can in about 20 minutes, the actual regulations themselves. And then Sian is going to pick up the guidance and focus on some key issues which arise from the guidance and highlight some places where the guidance and the law are different. And then we're going to take literally 5 minutes each at the end of the session to cover 2 points that are linked to the lockdown regulations, but not directly arising from them. The first is the issue of vaccines, and which has been raised by a number of people in advanced questions in terms of what priority disabled people might have for the COVID vaccine, which is obviously directly related to people's ability to move around freely. And secondly, finally, I'm going to look at questions around access to education, and in particular, children and young people with EHC plans and the extent to which, as vulnerable children, they are entitled to and or required to attend school. So Sian, if I could ask you to stop sharing your slides so I can share the regulations, please. Thank you. And I'm now going to hopefully be able to share the amended, happily, Tier 4 regulations, which I hope you can see. And what's important to note about the Tier 4 regulations, first of all, is that they have been amended now to pick up the changes introduced as a result of the new national lockdown. So if we look at the shape of the regulations, the all tiers regulations as they're known, we see that in the schedules we have the different tiers of restrictions, and then we have definitions in Schedule 4 of the areas to which the tiers apply. And if we scroll down to the very bottom, we see that Tier 4 is now every area of England, apart from the territorial waters around the country and the airspace above. So if you're in the air, you might be outside Tier 4, but if you're in England on the ground, you are in Tier 4 now. So we can forget, for present purposes, about Tiers 2 and 3. And if we look at the shape of the regulations and how they fit together, they start, as you'd expect, with the introductory text and an important interpretation section, which gives us lots and lots of definitions of key terms. I'm sure we'll all be interested to know what alcohol means, for example. Perhaps more relevantly, the definition of care home taken against the Care Standards Act. For reasons of time, I'll just pick out 2 definitions that are going to be particularly important to this audience. The first of which is the definition of vulnerable in the regulations. So the conditions referred to in the definition of vulnerable person are, and then these are all of the defined conditions, and they include, for example, chronic or neurological conditions, which includes a learning disability. So in order to be a vulnerable person, you have to bring yourself within the definition here in the interpretation section. There's also a definition of what a person who has a disability is, and essentially it's the Equality Act definition that people will be familiar with. If someone has a physical or mental impairment that has a substantial and long-term adverse effect on their ability to carry out day-to-day activities. So if you're a disabled person under the Equality Act, you're also disabled for the purposes of the all-tier regulations. So moving back then to the table of contents, we can see that there are key definitions of concepts that we're now, I'm afraid, very familiar with. First of all, the concept of a linked household, which is the technical term for a support bubble. And we see a linked household as a household that's linked with another household in accordance with the regulation. And these are the kinds of households that can become linked. So a household with one adult, one or more children and no adults, one adult and one or more children, one or more adults and one or more children who are under the age of 1 or were under that age on the 2nd of December. And importantly, again, for this audience, one or more adults and one or more children who have a disability and require continuous care, who are under the age of 5. So there's a heightened age for the linked household for children if the child has a disability. So these are all the types of household that can choose to be linked with one other household, which is the second household, if everyone agrees. There's no limit on the number of adults or children who can be in the second household. They become linked households. They can stop being linked households, as you'd expect. And there's now a minimum period in which you would have to wait to change your linked household. You didn't used to be able to do so, I think, but now you can if you wait 10 days. And I think that's all I've got time to cover at this stage. Oh, and I should have said at the beginning, apologies, if you have questions for Sian or I, please do use the Q&A to ask them, and we will try and take as many as we can and see if we can cover at least the themes that people come up with in the course of the talk. So moving back again, I've got to lose the Q&A because I can't see anything, sorry, there we go, to the table of contents. We can ignore for present purposes linked Christmas households, Christmas is over, and look briefly at linked childcare households, which is a similar concept to the linked household concept, but one which is solely for the purpose of providing, as it says, informal childcare. And for reasons of time, I won't go into the technical definition of who a linked childcare household can be, but I think we worked out last time that you can be in both a linked household and a linked childcare household. That was a question that came up on the last occasion, and I'm not aware of anything having changed in that respect. We then get the tier restrictions brought into force by Regulation 8, and then the enforcement regulations, which we don't need to dwell on today. We are going to assume for present purposes that everyone wants to comply with the law, but if you don't, then these are the penalties that can follow. So what we really need to look at for today's purposes is, what do the Tier 4 regulations mean for people with care and support needs, and what are the restrictions that are imposed at Tier 4? So the first of the restrictions in paragraph 1 of Schedule 3A is the restriction on leaving home. And the way that this restriction works is that no person who lives in England now, Tier 4 area, may leave or be outside of the place where they are living without reasonable excuse. And that's the key phrase. Do you have a reasonable excuse for being outside of your home, in essence? And very importantly, the circumstances in which a person has a reasonable excuse include, keyword, where one of the exceptions set out in paragraph 2 applies. So for the purposes of the restriction on movement, on actually leaving our homes, you don't have to have one of the specified exceptions in paragraph 2. Those are merely examples of reasonable excuses. And of course, if you can show that you have one of those exceptions, then you've got a cast iron defense if you're challenged for being outside of your home. But you can have another reasonable excuse. The question is whether it would be accepted to be reasonable. But if we look at the specified exceptions, the things that you're specifically allowed to leave home for, the first is that it's reasonably necessary for you to leave home in order to buy goods or obtain services from any of the specified businesses, for yourself or for vulnerable persons, to obtain money, to take exercise. Now this, of course, is very important. So if it's reasonably necessary for you to take exercise outside alone, or with one or more members of your household or your linked household, or where the exercise is being taken as part of providing informal childcare with people from the childcare household, or with one other person who's not a member of your household, etc. So you can exercise with one other non-linked person as well. And the regulation, and this is one of the issues that we'll look at in terms of the difference between the law and guidance, does not say anything to limit the number of times you can do that. It simply has to be reasonably necessary. And of course, what is reasonable, I'm sure, would be judged by reference to any guidance that has been issued. But it may be that in what's reasonable for one person to do may be very different for what is reasonable for another person to do, which the guidance itself now does begin to recognize. So there are some other specific reasons why it can be reasonably necessary for you to leave home to attend a place of worship, for example, sell or buy a property, visit a member of a linked household, collect takeaway food, etc. You can specifically go to the recycling centre as well. Importantly, when you're looking at the limits in terms of the number of people that you can do these things with, no account is taken of any person who's present as a carer for a person with a disability who needs continuous care. And we raised last time that the concept of continuous care may be somewhat problematic in situations where a person, for example, may have fluctuating needs of care. But hopefully that will be given a relatively generous interpretation. But there is a very specific and strict limit that there are no more than 2 people present in the capacity of carer, which suggests that those who need 3-to-1 care cannot take, more than suggests, it states that those who need 3-to-1 care cannot take advantage of that exception. Whether that creates any form of discriminatory impact, of course, would need to be judged in relation to some specific facts. We then got the exception in relation to work and other related matters. So again, the same test always applies. Is it reasonably necessary for you to leave your home? So you can't simply say, oh, well, I have a job, therefore I can do what I like, I can leave my home. It's still got to be reasonably necessary for you to leave for the purposes of work. And it specifically says here where it's not reasonably possible for people to work from home. To provide care and assistance, this is important for us, including relevant personal care to a vulnerable person. Now, we saw that definition earlier, or to a person who has a disability. So you can leave home to provide care or assistance meaning help, of course, to someone who is either disabled and or vulnerable. Again, fairly broad definitions there. You can leave home to provide emergency assistance to anyone. You can leave home to fulfill a legal obligation. So if you've got a duty to do something, or you need to participate in legal proceedings. To access critical public services, including but not limited to social services, or to access services provided by voluntary or charitable services, including food banks. The next relevant exception is medical need. So if it's reasonably necessary for you to leave your home to seek medical assistance, etc., then you can do so. But also for our purposes, if you need to visit a person receiving treatment in a hospital or staying in a hospice or care home, or to accompany them to a medical appointment, and you're either a close family member or a friend or a member of their household. So there's an issue that arises there in relation to supported living, of course, because there's a difference of treatment. And it may be that in the supported living context, you need to rely on a different exception. For example, the exception we just saw about providing care and assistance to a vulnerable person or to a disabled person. So you don't need to have more than one of these, as we know. You only need to be able to find one of the exceptions that applies. There's then a specific exception in relation to support and respite. So support groups, respite care can continue. Deathbed visits and funerals, marriages, some specific exceptions in relation to children that may be relevant, and then others, of course, that may be relevant in specific circumstances. In terms of sport, we know that outdoor sport can continue for disabled people, persons who have a disability, not for under 18s generally anymore, as was previously the case under Tier 4. So those are the examples of exceptions in relation to leaving home. But again, to emphasize, you can also leave home for other reasons if you have a reasonable excuse. However, the approach to gathering is quite different. And the way that gathering works is much stricter. So no person may participate in a gathering in the Tier 4 area, which consists of 2 or more people, unless one of the specified exceptions in paragraph 6 or 7 apply. So if you want to gather, i.e. meet with another person or more than one other person, this time you have to find one of the specified exceptions in paragraph 6 or 7. And that's essentially the case whether it's indoors or outdoors. And also, unsurprisingly, you can't hold or facilitate gatherings unless some very strict parameters are met. But given time, I'll just focus briefly on some of the key exceptions in relation to gathering. As you'd expect, same or linked households. So if you're in a support bubble, you can meet up. If the gathering is reasonably necessary for the purposes of specified educational training now. So for example, the education activities of a school or a provider of higher education in particular circumstances. Importantly, for present purposes, provision specified in an education, health and care plan is included. So it's not just education broadly, it's education within one of these very specific described situations, which we see listed from A to L. There's then another gatherings necessary for certain purposes provision. So work again, provision of emergency assistance, to enable one or more persons in the gathering to avoid injury or illness or to escape a risk of harm. That might be relevant because I'd suggest that illness there must include mental illness. So if people need to meet up to enable one of them to avoid a deterioration in their mental health, as long as that would be clinically identifiable, illness means something that is clinically recognized, then you may well, or you should be able to bring yourself within exception 3. Again, we have care or assistance. So you can meet up to provide care or assistance to a vulnerable person or a disabled person, including but not limited to relevant personal care. Legal obligations and proceedings, support groups again. So it's very clear that support groups can continue to meet and respite care provision can continue, and others that are going to be less relevant for our specific purposes. We see the full list extending to 17 different exceptions here. And then there are 2 exceptions that only relate to indoor gatherings and certain outdoor gatherings, visiting a dying person, but importantly for us, the visiting provision for people in hospices or care homes again. So the person is visiting a person receiving treatment in a hospital or staying in a hospice or care home, or is accompanying the subject to a medical appointment. Again, allows you to meet up and to undertake that activity. Now, whether or not, of course, you'll be able to actually visit is not just contingent on these regulations. It may well be that the provider, for example, the care home, is not willing to allow face-to-face visits, but that's a secondary issue. In the first instance, what the regulations make clear is that visits can, in principle, go ahead, subject, of course, to necessary measures that may be put in place, which Sian may look at when we get to the guidance. Now, I think that's what I needed to say for present purposes. If I had time, I'd look at the part 3 measures in relation to closure of and restrictions on businesses, what's required to close, what's not required to close. But I think we'll just see if there's any specific questions on that in the Q&A, because otherwise I'm going to stop there and let Sian, I think, put any questions to me that may have arisen in the first 15-20 minutes or so of the talk. Sian, if I stop sharing, hopefully I can bring you back in and yeah, you can quiz me on anything that's come
Great.
up.
So Steve, you won't be surprised to know that we've got lots of questions. And just to make clear to everyone who's attended, although we're happy to deal with general questions, we can't answer questions on specific circumstances. Some of the questions that we've had in advance of this have been quite specific and identifiable and would need their own legal advice, but we can answer questions on general topics. So some of these I think are possibly a bit sort of premature in that they need to be looked at once I've spoken about the guidance, but nonetheless it's fun to quiz Steve, so let's do it anyway. So if there is more than one household providing care to a vulnerable adult, is that permitted under the regulations?
Yes, in principle. So if we think about, I think we should always focus on the gathering restrictions because they're tougher. So if you're allowed to gather, then it seems to me you're allowed to leave home. So if we think about what gathering restrictions, or put the other way, what the exemption is in relation to the restriction on gathering in relation to provision of care, it's that it's reasonably necessary to provide care or assistance to a vulnerable person. So say you have two separated parents with a disabled young person who lives independently. It may be, on the facts of that case, that it's reasonably necessary for both of those parents to provide care or assistance to them. It may not be. So it will be a factual question. What you have to be satisfied of is if anyone challenges you, that you'll be able to show that it's reasonably necessary for you to be providing that care or assistance in the context of what anyone else is doing, both professional or family carers.
And then there was a related question about the situation where you've got two family members, both involved in caring for a vulnerable adult. And the question was whether there would need to be a sort of best interest decision as to which of those should effectively form the sort of the support bubble or the linked household with the vulnerable adult. But I think in light of what you've just said, that isn't necessary because actually both of those households can carry on providing the support.
Well, it's very interesting, isn't it? I would probably still like, if I was in that situation, to be in the support bubble, because once you're in a support bubble, you can do whatever you like. And you don't, within reason, of course, but you, in terms of the law, you can meet up full stop as a member of a linked household. So there's clarity there, isn't there? And given how uncertain and difficult life is for everyone at the moment, clarity is a good thing. So it may be the answer to that question is yes, I think, and that actually there would have to be a best interest decision taken for a person who lacks capacity as to which household they should link to. But if you're not the linked household, that doesn't mean you can't see them. I think that's the really important point, and that's what people perhaps are getting confused about and thinking, oh, well, if we're not a linked household, we can't do anything, because then you need to look at everything else, and in particular, this provision around care or assistance. And I don't know what you think, Sian, but I think assistance should be interpreted quite broadly there. It's, you know, it's help, isn't it? And that could be emotional support, perhaps.
And also, just sort of from a slightly nerdy statutory interpretation point of view, these are all restrictions, and so they're exceptions to the general principles of people's sort of freedom of movement. And the general principle of statutory construction is that you interpret restrictions or limitations in quite a narrow way. So I think that would support the view that actually you're looking more to find a way that something can happen than to find a way that it can't.
Yeah, and we need to give full weight, and again, being a bit nerdy, to the introductory phrase in each of the exceptions, which is often, and is here, reasonably necessary. So if what you're doing is reasonably necessary, it seems to me likely, and I should add to Sian's point and give another disclaimer, which is, of course, we're not giving any legal advice here today, particularly given that these things have criminal sanctions associated with them. But it seems to me likely, in broad terms, that if you genuinely can show that what you're doing is reasonably necessary, there will be a way in which you can construe one of the exceptions to support it. The intention, and again, you know, we look at intention when we're thinking about statutory construction, is to ensure that people who need to be outside or to meet up can do so, and very much that those who don't. And so if what you're doing is in line with the spirit of that and the purpose of these measures, hopefully one of the 17 different exceptions or whatever it might be will support you to do the thing that needs to be done.
I mean, generally, if what you're looking to do is to provide support to a vulnerable person, then you know, just as a matter of logic, it would seem to be likely that it's reasonably necessary.
Yeah.
But obviously, that there are criminal sanctions, so it is important to be cautious.
Yeah.
Okay, here's an interesting question about exercise. Somebody who uses a power chair or a mobility scooter going out, does this count as exercise?
I think this is genuinely problematic, actually, because as I understand it, there's been a fairly deliberate restriction on this exception, which is to make it about exercise as opposed to leisure and recreation. And exercise is generally seen as involving physical movement. However, in order to, these regulations have to be interpreted in a way that seeks to avoid unlawful discrimination. And so again, in line with Sian's general point about statutory construction, a generous interpretation, I think, of exercise needs to be given. But at the same time, if you're literally not moving, it's hard to see that you can bring yourself within that definition.
I suppose the question is, how do you define exercise?
Yeah.
Because obviously it is physical movement, but also the benefits of exercise include fresh air and the sort of mental well-being side of it, which are entirely achievable by somebody who is physically constrained in terms of their movement ability.
Absolutely. And I don't think the intention was to discriminate against severely disabled people. And so to the extent possible, the regulations need to be read with that intention in mind. But I've just gone to the interpretation section, and as far as I can see, there's no definition of exercise. So it gets its ordinary meaning. So we need to get our dictionaries out. But without doing that, we all know, I think, that exercise is something that involves movement. And so I suppose the first thing is, well, can you come with any of the other exceptions? But actually, you might not be able to, because you just want to go out for yourself and look after yourself. Obviously, you could say, well, if I don't, I'm going to suffer from a mental illness. But that's a relatively high threshold, and it's quite an extreme bar to have to get yourself across if all you're trying to do is get some fresh air and see a few trees. Not in any way denigrating how important that is to people. It's hugely important to lots of people, myself included, but it doesn't feel like you should have to get a doctor's note to prove that that's reasonably necessary. So unless you're going to give us any answers from the guidance, Sian.
I'm not, unfortunately. The guidance talks about exercise in terms of physical activity, so it gives lots of examples, including jogging, swimming, walking, etc., but obviously doesn't engage with the question of the benefits of fresh air without the sort of physical movement.
I think it may be something that needs to be taken up by the representative organisations, and given that we know we're in this lockdown, we think, for at least 6 weeks, and who knows how long it will be, it's well worth getting that point clarified. Not because I expect rafts of disabled people are going to end up in the magistrates' court or with penalty notices, but just because of the chilling effect on people of lack of clarity. And one of the themes from the questions that were coming in and that I was skimming through was providers and others restricting people on the basis of what might be said to be a misunderstanding of the law. And so we do need to be clear, because a lot of the people we're helping, talking about today, supporting, hopefully, enabling for themselves, are actually at the mercy in many respects of care providers and others who may not have access to legal advice and may be taking a fairly blunt view. So the fact that it's at best unclear is troubling.
Yeah, I think that is quite an important point, given that one of the lessons I hope we've learned from lockdown 1 is the effect on people's mental well-being of having their liberty constrained in this way, and the sort of growing mental health need arising from that, and so if that can be alleviated by people having access to the outdoors, I would have thought that's a really obvious point that ought to be dealt with in the guidance.
I completely agree.
Okay, a last question on definitions. Is there a definition of medical treatment in the regs?
Not that I've seen. Let me double check, just to prove that we're doing this live. Oh, hang on, my laptop battery's running low. I think I better fix that before I do anything else.
Well, while Steve's doing that, we had quite a few questions about the question of supported living and whether someone in a supported living placement is able to form a linked household relationship with another household. I am going to talk about that a bit in relation to the guidance, because there is some specific guidance on supported living. But Steve, perhaps you could have a think about that while you're multitasking.
I've plugged in, Sian. Remind me what the definition.
So the first question was about the definition of medical treatment.
Medical treatment, thank you. No, I didn't think it was in the interpretation section. It's not. So that again supports the broad construction that I think we want to give generally to the exceptions and the narrow ones with the restrictions, which would be any medical treatment, mental or physical health related.
And in fact, the guidance, again, just sort of drawing that link, the guidance does talk about attending support groups, and I think it's in the regs as well about the maximum number of people that can attend a support group.
15, yeah.
So that would tend to suggest that support groups are allowed, and that's arguably a form of medical treatment, or at least some groups would be.
Yeah.
And then the other question that I sort of threw at you was about the question of whether someone in supported living is able to form a linked household relationship with another.
I think
household.
the short answer to that, and it's an issue that I'm actually involved in some litigation about, is what kind of supported living are they in? Because if they're in an individual unit where they live on their own, then it seems to me that they come within the one adult definition of a first household, and you need to be in a first household to form a support level. But if they actually are living in a setting that is communal in some respects, for example, with shared facilities or shared living space, then they may well not be, because they will be in a household with those other people, which comprises more than one adult, and they can't come within any of the other exceptions. So it's unhelpfully unclear, I would suggest. But if the person has their own home, their own flat, and it's completely self-contained, then I think the answer is obviously yes.
And then there's a related question, which I suspect may have the same answer, about whether patients detained under the Mental Health Act are able to form a linked household relationship.
Yeah, I think that does, doesn't it? And of course, that's even more complicated because the nature of that accommodation, if you like, is subject to change depending on the person's health and the way in which the responsible clinician and others view their circumstances. So yeah, I suppose if they're on their own, but I suppose a person who's in segregated scenario is probably unlikely to be able to benefit from a linked household. So I would imagine most people who are on a ward won't be able to.
Yeah, because of the living arrangements.
Because of the living arrangements, but
potentially someone who's in a community setting who's got their own front door might be able to benefit from that.
Absolutely, but also let's not get hung up on linked households. You know, they are only the easiest way to get through this maze. They're not the only way, and I would have thought certainly for people who are subject to detention under the Mental Health Act, the need for care and assistance from family members and others pretty obvious, isn't it? And it being reasonably necessary to, for example, allow leave to continue and support from family members. And again, I think what is particularly alarming about the way in which the restrictions are applied in practice is blanket policies, something that our colleagues and us have been banging on about ever since lockdown 1, isn't it? That if you have a situation where a hospital, for example, says, "Oh, we've cancelled all leave," you know, serious alarm bells should be ringing, because that's just not proportionate, and it's not, as we've seen, anything like what the regulations actually say.
Yeah, I mean, we talked quite a lot about that when we did this session on lockdown 2, and the fact that the ground had shifted a bit away from blanket policies and towards a much more sort of nuanced approach to risk assessment. And I suppose one of the hopes for this lockdown is that isn't lost.
Absolutely, we need no retrogression, don't we? I mean, we know we're in this for the long haul, and the only thing that can make it a bit better is if lessons are learned. And to the extent they clearly have been, and we see a more sophisticated approach throughout the regs, but there are definitely still some sticking points, and I think we've identified 2 that greatly trouble me. One is exercise, and one is supported living. I think there's an unhelpful lack of clarity in relation to both.
Shall we move on to my slide, and then we can pick up some more questions afterwards?
That's great. I'll start reviewing the questions to put some nasty ones to you, Sian.
I'll just attempt to screen share without my camera falling over. Okay, hopefully that's working. Okay, so I'm going to look at the guidance. I will make sure that everyone who registered for this has access to the slides afterwards. Just some resources. Obviously, this is very much an evolving situation, so please keep checking the guidance. The guidance is being updated, and so obviously it needs to be looked at regularly. Just to pick out a few of the topics, and I think you probably had a heads up that this was going to be one that we needed to pick out, this issue of going out for exercise. And the reason that I've picked it out to comment on is firstly because obviously it's a sort of an important daily event, and obviously important to people's well-being, but also because it highlights, I think, the difference between what's in the regs and what's in the guidance. In other words, what the law tells people that they can and can't do, and what the government advice is. But the key point to bear in mind in relation to the guidance is that it doesn't have the force of law. This is guidance and not law. So what the guidance says about exercise is that you can leave your home to exercise. It says this should be limited to once per day, and you should not travel outside your local area. But of course, as Steve has discussed in looking at the regulations, those restrictions are not in the regulations. And also there's no definition of the local area. So if this were to be regarded as law, it would probably be too vague to be enforceable, or potentially would be too vague. The guidance says you can exercise in an outdoor public place by yourself, with the people you live with your support bubble, if you are permitted to form one. We've already talked about the circumstances for support bubbles and childcare bubbles. Or when on your own with one person from another household. And this is the same as the rules that applied to those who were in Tier 4 immediately before the new lockdown. Personal training can continue one-on-one unless everyone is within the same household or support bubble. Children under 5 and up to 2 carers for a person with a disability who needs continuous care are not counted towards the gatherings limits for exercising outside. And I've just sort of put in a note there. What about the person who needs 3-to-1 care to access the community? It seems to be somewhat arbitrary in that there is some recognition of the fact that there are going to be people who need carers to be able to access the outdoors for the purposes of exercise. But then why have a limit on the number of carers? Because obviously there are going to be circumstances where someone needs more carers than the guidance is saying they can have. It goes on to say, if you or a person in your care have a health condition that routinely requires you to leave home to maintain your health, including if that involves travel beyond your local area or exercising several times a day, then you can do so. And this was an amendment to the guidance on the 6th of January. So this guidance, I think, was published on the 30th of December. And within a week, it's already been amended because of obviously difficulties that relate to those with disabilities, whose health condition means that they need to exercise more often or outside of their local area. And then it goes on to say, when around other people, stay 2 meters apart. I think we're all very familiar with that. So moving on to another sort of potentially relevant and difficult area, this is visiting care homes. And what the guidance says about this is that visits to care homes can take place with arrangements such as substantial screens, visiting pods, or behind windows. Close contact indoor visits are not allowed, and no visits will be permitted in the event of an outbreak. What the guidance does is to talk to reference other guidance on visits to care homes and separate guidance on supported living. Now, the guidance goes on, before I look at those separate forms of guidance, this main guidance also talks about compassionate visits. and says you may also leave home to visit someone who is dying or someone in a care home if permitted under care home guidance, hospice or hospital, or to accompany them to a medical appointment. So really there are two sort of sides to this. There's the reasonable excuse for the person doing the visiting, but then there's also the conditions in which they're permitted to enter a care home or another placement for the purposes of a visit. The visiting care homes guidance, and I've given a link to it in the resources page, it does make clear that the question of visits to care homes should not have a sort of one-size-fits-all approach. And this does seem to be a bit more of a reflection on what happened during lockdown 1 and a bit more of a nuanced approach. But it requires that there be a risk assessment by the care home. The default position in this guidance is that visits should be supported and enabled where it is safe to do so. But also we're layering on that now this guidance, which is saying arrangements such as substantial screens, visiting pods, or visits from behind windows, and saying that close contact indoor visits are not allowed. So on the one hand, there is a recognition that visits are important and should be supported, but there's also some fairly stringent constraints being put on how that can happen, and some constraints which in the case of some care home residents are going to make the visits either very difficult, potentially distressing, or perhaps of no benefit if they're not able to go beyond a substantial screen visit. The visiting care homes guidance goes on to say that the care home registered manager is responsible for setting the visiting policy, that they should do so on the basis of a dynamic risk assessment, taking into consideration the needs of individuals within their home and with regard to the advice of the local director of public health. The dynamic risk assessment that's referred to in the guidance should consider relevant factors relating to the rights and well-being of the residents. It may be appropriate or necessary for providers to apply different rules for different residents or categories of residents based on assessment of risk of contracting COVID, as well as the potential benefits of visits. So there is a recognition there that this is all about risk assessing and balancing the risk against the benefit. And as I said, that we have to move away from that sort of one size fits all approach. There has to be a much more individualized approach. And sadly, I suspect it's the case that some care homes are not individualizing or personalizing their risk assessments as much as they should be. But clearly these are very difficult decisions that are having to be made not just once, but on a regular basis. We had quite a lot of questions about visits to supported living placements, and I think we've already talked about that to some extent, because clearly supported living is a sort of umbrella term and can include living arrangements that frankly cover the whole range of individual flats to a good degree of communal living. So this guidance, although it makes clear that it applies as much to sheltered and extra care accommodation as it does to supported living, also sets out that there are different models of scheme, and so there isn't a one size fits all approach. But it does say that there should be an avoidance where possible of sharing staff between settings, which I think is quite difficult to achieve in circumstances where there's obviously a high level of staff sickness and agency staff covering. So that might be desirable, but whether it's attainable is another matter. The guidance on supported living goes on to say, fairly obviously, no one with COVID symptoms should visit. Nobody who should be self-isolating should visit. If there's a communal garden, which can be accessed without going through a shared building, then using this space for visits should be encouraged with social distancing. alternatives to in-person on-site visiting should be explored, including the use of telephone or video, arranged walks in the park or outdoor spaces. And my view is that actually that's something that should be featuring in care and support needs assessments, to look at whether P needs support in order to be able to have those arranged walks in the park or outdoor spaces, in order to engage in visiting. So combined exercise and visiting, and then some other perhaps obvious points, but nonetheless contained in the guidance. The guidance goes on. I'm not going to go through all of this. It is in the slides, but says that visitors should be limited to the current guidance on group meetings to preserve social distances. And then there's guidance on hand washing, etc., which we're all now quite familiar with. And then the last point that I want to pick up on under this section is about care home residents going to their family homes. In other words, the idea of them forming a support bubble, if permitted to do so, and then actually leaving the care home. So rather than having family members come to them, that the person in the residential placement going outside of the placement. The guidance says you can leave home to visit people in your support bubble if you're permitted to form one. That's going to be difficult for someone in a communal living arrangement. To provide informal childcare, theoretically possible. To provide care for disabled or vulnerable people, and this is where I think there's a sort of a lack of clarity, because of course the person who needs the care could be travelling for the care to be provided to them, rather than the sort of perhaps more traditional model of the carer travelling to the cared for person. So there is potentially scope for the person to move to be cared for. And again, to provide emergency assistance. Again, there may be a situation where the assistance is provided by the cared for person going, or possibly for the purposes of respite, depending on the main care arrangement. So that there are some potential sort of wrinkles within the guidance permitting a person who's in a care home to go to their family homes, but only if some quite specific conditions are met. Just a quick word on, and I think I've sort of flagged this up already fairly extensively, but about the sort of interplay between well-being and these restrictions. There was guidance issued by ADAS in November of last year, and that obviously predated lockdown 3, but nonetheless the guidance was specifically aimed at managing mental health through the pandemic, and it gives some examples within that guidance of what ADAS consider to be good practice in terms of looking at sort of fairly creative and cooperative solutions, so that people's mental health is supported and their well-being is supported, notwithstanding the limitations on services and the restrictions. And then, of course, again in November, so pre-lockdown 3, we had the Vice President of the Court of Protection recognising expressly that receiving visitors is an important part of care home life, and that maintaining some opportunities for visiting to take place is critical for supporting the health and well-being of residents and their relationships with friends and family. And to some extent that is now reflected in the guidance on this lockdown, and on that in that care homes guidance. So that there is a recognition of the benefits of having visits for care home residents, but there doesn't seem to be a great deal of engagement with the fact that there are going to be some residents for whom visits behind a screen or in a garden are just not going to provide them with the sort of the well-being or well-being benefits that a more interactive visit is capable of bringing. So a quick word on the Care Act. No new easements. We had those back in April, but they haven't been repeated for lockdown 3. Care Act duties remain in place regarding assessment and care provision. Obviously, one of the key parts of the Care Act in play is the Section 1 duty, which is to promote individual well-being. Of course, assessments are capable and have always been capable of being conducted by remote means, but the person assessing needs to be satisfied that the person being assessed is able to participate in that way. Completely unrelated, but it's something that was asked about, and so I'm just going to say a quick word on it before we look at some questions. Vaccine priority is obviously a hot topic at the moment. So the current criteria for vaccine priority are all age related. So priority 1, residents in a care home for older adults and their carers, goes down the list. As you'll see, as it goes down the list, it gets younger. It's only when you get to priority 6 that you get to individuals aged 16 years to 64 with underlying health conditions which put them at serious risk of disease and mortality. But there is no priority within these groups for those who live in care homes or residential placements, but who have learning disabilities and who don't fall within these age-related categories. And that lack of priority is being challenged by way of a threatened judicial review because of the equalities implication and human rights implications of that. Steve's involved in that case and might want to say a bit more about it. But just to flag up that is obviously a core concern of those who support and advocate for those with learning disabilities. So I'm just going to stop sharing and see if there are any questions.
Oh, there are, Sian. There certainly are. Thanks again for a really helpful run through and the guidance there. Just to pick up the final point, the Secretary of State's response on that proposed judicial review, which Bindmans are instructing me on, is due next week. So we'll see where we get to on that. The questions that are coming in thick and fast include the following. Can people move in with others to provide emotional and mental health support during the national lockdown? Not so much as a matter of law, but as the guidance suggests that would be permitted, do you think, Sian?
You can move house. There's no restriction on moving house. So if your decision is that you're going to move house and your motivation for doing that is to provide support to somebody, there's no restriction on you doing that. As I read, a lot of sort of relatively new relationships have become much more stable because people have moved in with each other during lockdowns.
Quite, yes. So
and probably the opposite as well.
Yes, perhaps. Well, actually, there's a serious point there, isn't there, around escaping domestic violence, for example.
And just to be absolutely clear, and this was the case under lockdown 1 and lockdown 2, there is no restriction on somebody leaving their home where they are fleeing domestic abuse.
Yeah.
There's no restriction on moving house. You can move house, and if you're fleeing domestic abuse, that's an absolute essential reason for being outside.
Absolutely. Can you visit a person? Sorry, slightly different point. Nice, sharp question, literally, Sian. Can you visit a person in a care home if you've had the jab?
That's a very good question. I mean, there's nothing in the guidance on that. I mean, obviously, the purpose of the vaccination programme is to put people in a position where they don't pose a risk to themselves or others from the virus. At the moment, I would say no. Because that's not, as I understand it, within the regs. It may form part of a risk assessment being carried out by a care home. And obviously there is a lot of guidance about sort of dynamic risk assessments. And I suppose as we move to a situation where more people are vaccinated, then that would have to form part of that dynamic risk assessment.
Absolutely. I think that must be right.
There was actually quite an interesting question that someone had posted earlier about whether care homes and agencies could stipulate that carers would only be employed if they've had the vaccine. And I think that's probably quite an interesting point of employment law that I am not qualified to answer.
Yes, it's a very interesting legal question that I'm not going anywhere near, Sian, but yes, it's a quite an important one that's going to be coming up. Perhaps employment colleagues need to have another webinar on that. A question that is definitely one, well, just to pick up on that point, Sian, in terms of having the jab and what it means for visits. The way I read the regulations is they simply permit care home visiting, full stop. And then it's the guidance that actually essentially restricts that. And so a care home, I suppose, as a matter of law, could say, yes, we'll allow people to visit and see each other face to face if they've had the vaccine. But that wouldn't be consistent with the government's guidance. And I can imagine there might be, for example, some insurance implications.
Yeah, I mean, care homes set their own visiting policies, and they're entitled to do that. But they are subject to guidance, not just this guidance, but guidance from ADAS as well, which is telling them that they have to take a dynamic risk assessment and they have to keep that updated. So yes, I mean, a care home could probably just have an open door visiting policy, but obviously they would be vulnerable the residents would be vulnerable to the virus, and they would be vulnerable to legal action for not preventing it.
Absolutely, whether that's in contract or negligence or in various other potential regulatory action could be taken as well. So it's a complicated picture, isn't it? And of course, we're looking quite narrowly at the lockdown regulations and the guidance that comes under it, but actually providers and others will be taking a whole host of other considerations.
And I would have thought also the CQC would be concerned with whether providers are complying with guidance, whether it's law or not. It is government guidance, and I'm sure the CQC would be concerned. Yeah.
So then another thorny one in terms of the possible tension between law and guidance, which is again put wonderfully shortly. What about if your linked household is in another area, say an hour's drive away? Does that, certainly from the regs point of view, I don't see any issues. What about the guidance?
No, I mean, again, the guidance is very clear when it sort of talks about the restrictions. It does carve out the exceptions for linked households. So if your linked household is some physical distance away, then I don't see a difficulty with that under the guidance. And where it talks about the local area, that is really only in relation to taking exercise, and it isn't defined either.
That's right. So it's as you say, almost impossible to enforce that, isn't it? It's what is your local area? You know, it's very, people will take different views about that, won't they? Two other really excellent thorny questions. Would a men's mental health support group be allowed to meet up to play a six-a-side football game to support group members with their mental health? What do we think about that, Sian?
Well, support groups are allowed. There isn't a restriction on what activity the support group could undertake. I think if it was therapeutically necessary and was evidenced as being therapeutically necessary, then potentially yes.
I agree. I was actually just asked what the definition of a support group was, and I've just pasted it into the Q&A, and I've got it in front of me here. And I agree. I think that the support group is a group that's providing mutual aid therapy or any other form of support to its members, and does include those with any long-term illness, which would include many mental health conditions, of course, or disability. So again, we're not giving any advice.
No, I mean, I certainly wouldn't say book the pitch.
No.
But I can see the possibility for that. Absolutely,
and I'm very well aware that's a really serious consideration. You know, the benefits. That I think there's a reason, isn't there? Again, if we think about the purpose of all this, there's a reason why disability sports have been allowed to continue, even though children's sports haven't. Children's sports themselves were allowed to continue because of the mental and physical well-being implications for children. But even though that's been taken away, disability sports have remained. And I think this is an example of that. So I think the question is the primary purpose support, or is the primary purpose to play football? Yes. And if the primary purpose is support, then just sort of my initial instinct is that it would be allowed. Yes, and I think even the playing of the football may itself be supportive of people's mental health. So, you know, there's a number of ways you might be able to get that through. Sorry, I potentially could talk about that one for half an hour ourselves, couldn't we? One more question, John. I hope it's not about football. No, I promise. Sorry, I chose that one. Are there any restrictions for people using transport as an activity?
Transport as an activity, as in cycling?
Well, no, moving. Sorry, I should have given you the context of that. It was in the context of day opportunities for vulnerable people. So,
as in going on a bus ride,
or a minibus, or anything that stops people moving around to access day opportunities.
No, I don't think there is. Certainly nothing in the guidance, and I don't understand there to be anything in the regs either that would prevent that.
But one of the points that was made is, well, and this is another question I answered in writing, why are some providers stopping activities then when the encouragement is that they should continue? I think the answer to that must be that it's open to providers, particularly private providers, to have more restrictive measures in place and to take a view that actually their activities aren't safe at the moment, and subject to human rights implications which may arise, and the need to be proportionate in terms of not immediately withdrawing things or not taking things away that are going to cause huge detriment to vulnerable people. That must be okay.
And they're all having to do their own risk assessments. So, it depends on the premises, it depends on the cohort who attend, that, there are so many different factors that we're never going to be able to say, this group can always continue, or this group can't, or this day centre can continue, or the other can't.
Exactly.
There are so many factors in play.
What we can say, I think, is that the regulations actually don't prohibit that much. The guidance goes on to prohibit a little more, or strongly encourage at least a little more not to happen. But most people who want to do things that will benefit disabled people and elderly people will be able to do so. Whether they then, but that's very different, isn't it, from them being required to do those things at a time where there's a pandemic.
And I think the things that, it is a real difficulty with things like day services closing, and there is a question of how the eligible needs of people who attend day services are being met when the day service is closed. But the important thing to remember is that a day service is a means of meeting needs. It's not a need in itself.
Precisely, and the Care Act makes that
anyone whose care and support plan says they have needs X, Y, and Z, those needs have to be met. But if they're currently being met by a day service, they don't have to be met by the day service.
That's absolutely right, and a critical change, of course, when the Care Act came in, to this broader obligation to meet need rather than to provide particular services, which has both advantages and disadvantages. But here there's an advantage, isn't there, which is you still have the right to have your needs met. Just before I do 2 minutes on schools, Sian, I just wanted to flag something that I think this session's really brought home to me with even more force, which is the problem that's created by the last minute announcement of these measures, and the disproportionate, I suggest, effect that has on the kinds of groups that we're talking about today, disabled people and those who are otherwise vulnerable or in need of care and support. Because unsurprisingly, there's a lot of confusion, and people haven't had the opportunity to take advice or to digest what's coming out. The fact that guidance is still being amended on the day the national lockdown comes into force is really problematic. And so I suppose that, apart from hoping that we can persuade government not to keep doing it this way, what can we say that might be useful in that respect? Perhaps that there is a degree to which a common sense approach is needed. And actually the analysis that we've done, the pathway through the regs and the guidance, there's very little in there that makes me think, well, that just doesn't make sense. Most of it is what you'd expect it to say. I think there are some problems like 3-to-1 care and exercise and supported living. But apart from those sort of thorny problem issues, most of it is kind of what you'd expect. And so if people are making decisions that don't seem to make sense, it's worth pushing back against that and challenging it and looking out for blanket policies, perhaps.
Yeah, and just on a slightly more positive note, there does seem to this sort of legislative and guidance response to lockdown 3 does seem to have taken on board some of the lessons from lockdown 1 and lockdown 2.
Definitely.
So, for example, I don't want to tread on your toes with the education stuff, but we don't have any sort of suspension of special educational needs duties. We don't have the easements to the Care Act that we had back in April.
Yes.
And there is a more nuanced approach to the question of visits to those in care homes. So I yes, there's obviously room for improvement, but I do think that lessons have been learned to some extent.
I think that's fair, but I also think there's confusion, isn't there? So the fact people still don't know what's happened with the Care Act easements. There aren't any anymore, or they're none in force, allegedly. So if I do then just pick up the education point, just to emphasise what Sian's just said, it's vitally important that at present there has been no relaxation of the duties in relation to Section 42 of the Children and Families Act. So if a child or a young person has an education, health or care plan, they continue to be entitled to all that provision. Of course, it may be delivered in a different way, may well be delivered in a different way, but they are still entitled to it unless it's impossible in the current circumstances to provide it. Whether there will be a relaxation, I think, is a very interesting question. People keep asking me, I have absolutely no idea. One thing that may happen, of course, is local relaxations. That's a possibility, that the duties may be varied locally as opposed to nationally. Again, nothing I've seen that suggests that's imminent, but it's something that could be done if, for example, there was a crisis in a particular local area. But what might be the reason for the fact there hasn't been any of those relaxations this time is that, of course, the system is better prepared this time to some extent, and actually the response doesn't necessarily need to take away therapists and others who are there to support children and young people with special educational needs. And there's been a strong push back to make sure that those auxiliary professionals are available to continue to provide therapy and other services to children and young people this time. But one of the big questions that people have been asking is about simply access to schools. And on this, I wanted to share one of the guidance documents, one of the deluge of guidance that, of course, has necessarily come out in relation to lockdown 3, which is this document described as restricting attendance during the national lockdown schools, January 2021, of course. And I'll just go, for reasons of time, straight to the attendance section. And it says that during the period of national lockdown, schools remain open to vulnerable children and children and young people, children who are children of critical workers as well. We'll put critical workers aside for present purposes and focus on vulnerable children. And just to emphasize that any child who has an EHC plan is within the category of vulnerable children. Now, that may itself be problematic and prejudicial and inappropriate language, but it does mean that they are eligible to continue to attend school. Two issues then arise. Some people are saying, well, despite the fact I've got an EHC plan, or my child or young person's got an EHC plan, the school's saying we can't go. That, in my view, seems to be at best inconsistent with the guidance. On the other hand, what about children and young people who do have an EHC plan, but whose parents would much prefer them to be at home? Do they have to go to school? And that's the question I think we get some help with from this guidance. So we see the definition includes all children who have an EHC plan. And we see that, top of page 26, schools are expected to allow and strongly encourage vulnerable children and young people to attend. Parents and carers are strongly encouraged to take up the place. So that does tend to suggest that there is a cohort for whom it may be acceptable for them not to take up the place, because it's not an absolute requirement, it's merely a strong encouragement. If vulnerable children and young people don't attend, schools should work together with the local authority and social worker if appropriate to follow up and discuss the reasons and consider whether it's in the child's best interests. So there is the possibility of a best interest decision being taken that the person should not attend. And if the schools grant a leave of absence to a vulnerable child, they should still speak to the parents and carers to explore the reasons for this. And any concerns raised, discussions should focus on the welfare and the need to ensure they access appropriate education and support while they're at home. And there we go. So that's the position in short, in terms of school attendance. If you are vulnerable, it's not apparently, according to this guidance at least, which is of course the official departmental position, an absolute requirement. It's something that is strongly encouraged and therefore I suppose might be described best as a presumption. Sian, I don't know if you're able to just skim to the bottom of the Q&A and see if there are any questions on that point. And I'll do likewise looking at vaccine issues in case anything came up on that. Well, just one question I'll pick up or it's not a question, it's a point. The guidance around care act easements still stands and local authorities do still have the ability to enact them, it's said. Well, yes, but that guidance makes crystal clear that in order for the local authority to move to the easements, they need to make a specific decision and comply with some fairly rigorous procedural requirements. And at the present time, no local authority has done that. So yes, the easements still remain available, to local authorities. But in terms of the guidance, at least, which is written in very strict and mandatory terms, no local authority has made the necessary decision to exercise the easements. And so at the moment, 152 local authorities in England are required to comply with the Care Act in full. One question on vaccinations, Sian, do direct payment carers have the right to the vaccine as carers in the same way as a carer who was working in a care home?
I don't know the answer to that.
Is that?
I mean, I would have thought if they're a registered carer,
Yeah.
which they presumably would be if direct payments are funding them,
yeah.
then the answer seems likely to be yes.
I think that's right, because isn't it the same for family carers as well? I think that isn't that the footnote into category 6 that says now that anyone who's potentially providing regular care and support can get into that category. I mean, it's not the highest priority, but it is some priority at least.
Yes.
Isn't it?
Yes, I think that must be right. I should just say that there were quite a few questions relating to mental capacity and decision making around vaccination. I think that probably goes slightly off topic for this webinar, but I think it is going to be a sort of thorny issue, and particularly when it comes to vaccinating those in care homes. The idea that, you know, a sort of a team of health professionals can just turn up with a box of vaccines and sort of vaccinate the whole care home in one fell swoop, I suspect will not be the case, because there will be people who don't have capacity to make the decision about being vaccinated, and for whom a best interest decision is going to have to be made.
If I remember rightly, Sian, there's some guidance on that produced by the team, isn't there?
Yeah.
There's, I think, some specific 39 Essex mental capacity team guidance on how to approach best interest decision making in relation to vaccination, which has been updated.
And I have had it coming up in a few COP cases recently, which aren't specifically about that, but it's sort of become an issue. I think one of the sort of key issues is who's going to make the decision, who is the decision maker in relation to that best interest decision. And my view is that it's obviously going to be the health bodies, because vaccination is a health matter, but because it's being sort of talked about in the context of care homes, it's sort of become tied up with care and support.
Absolutely agree. One other question on education: what about children who are awaiting the completion of their EHC plan and therefore obviously have quite significant recognised special educational needs? They are not within the automatic vulnerable category, but schools and local authorities can include any other child or young person who they deem to be vulnerable. And so there's a discretion there to include them. And I would have thought that if it's been accepted that a plan is required and it's merely a question of the local authority finishing the process, the discretion should pretty obviously be exercised in favour of treating that child as vulnerable as well. Okay, I think we're pretty much at the end of the time we have available, Sian. I think my favourite question that we haven't answered so far is, could I exercise my brain as a form of exercise? Well, I certainly hope this webinar has provided some brain exercise for everyone. I'm sure it has for Sian.
It's exercised my brain.
Exactly.
Does that count as my exercise for the day?
Well, I know. I was wondering about that. It's probably yet another day where we spent far too long on the screen. But I'm very grateful for all the questions that we've had. They've been excellent. I'm sorry that there remains so many that we haven't been able to answer today. But hopefully we've at least given people some clarity about where to look. And certainly in terms of the official lockdown rules, you can search for the regulations. If you search all tier regulations and go to legislation.gov.uk, you'll see what I've been showing you at the beginning of the talk. And if you search national lockdown guidance, the guidance.
Yeah, I've put a link to it in the slides, and also to the guidance on care homes and supported living. So hopefully that will sort of guide you to the resources that you need. And thank you all very much for all the really interesting questions.
Absolutely. And I think we should probably end by saying we hope we don't see everyone again, Sian, because that means there isn't lockdown 4.
Lockdown 4, yeah.
Who knows? Let's see what the future holds. Thank you, everyone.
Let's try and be positive.
Exactly. Let's hope this is the last 39 Essex Chambers.
If you never
lockdown.
see us again, it's a good thing.
Right. As with lawyers generally. Thank you very much, everyone. Have a good evening. And as we have to say at the end of anything at the moment, stay safe. Thank you all.
Thanks, everyone.